Hey, everybody. Good morning. The purpose of this meeting today, can you mute your speaker? Is to um, learn about the new requirements of this FinCEN law that is going into effect March the 1st. And I'm going to mute myself so that Duane can take over.
Okay. Can everybody hear me? Okay. Um, Sean, can you hear me? Okay. So anyway, so there on March 1st, settlement agents essentially are going to have to start filing what they call a residential real estate report. That report will be required in any non-financed transaction involving residential real estate that's purchased by an entity, and it also actually applies to gift transfers to an entity. An entity basically means anything that our investors would use to buy and sell real property, including LLCs, partnerships, land trusts, corporations, and other forms of entities we're all familiar with. A non-finance deal, unfortunately, includes true cash, not necessarily cash in a bag, but cash, paying cash from for your bank funds. It also involves transactions where financing comes through a hard money lender. Hard money lenders are considered cash transactions in the event that the hard money lender is not subject to anti-money laundering program requirements and suspicious activity reporting obligations. Typically, um, many of the hard money lenders that we deal with are not subject to those requirements, and if they are subject to those requirements, they're not necessarily following them. I'm not prepared to go down the rabbit hole today as to what all those requirements are, but just suffice it to say that we've all opened a bank account these days, and we know how many questions were asked by the lender or the bank to even open a bank account. They ask questions about where did your deposit come from? Who are you? Who are all the owners of the company? And that is anti money laundering requirement 101. And that's what this new residential real estate report does is the federal government is trying to kind of close a few gaps or a few holes uh, in the process so they can make sure they understand who is buying, holding, and ultimately selling residential real property. It's an area that is it's 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 a it's ripe for money laundering. It There's lots of ways that people can hide illicit funds in a residential real estate deal. So the important thing to understand about this new report is not necessarily uh, the fact that we have to do it, but simply that there's a little bit of information that a buyer is going to want to make sure that the settlement agent has in advance of the closing. And that information is going to include account specific information uh, relating to where the money's coming from. That's coming from the investor's own checking account. The settlement agent's going to need to know in advance of the closing what checking account is that money coming from? What's the routing number? What is the account number? What is the bank name where these monies are coming from? Even if that is a certified check, if you went down and got a certified check, the settlement agent needs to report where did that money come from. That also applies to the hard money side of the equation. So if somebody's borrowing money from a hard money lender, then prior to the date of closing, preferably several days in advance of the date of closing, the settlement agent's going to want to know where's that money going to come from and so I can start filling out this form. The form is not overly complex, but it is voluminous, right? There's over 100 fields that have to be filled out. Most of them are pretty routine: buyer's name, seller's name, purchase price, property address, all the stuff that you can imagine. It's fairly routine, and we all have to fill that in at some point during the process, whether it's on a settlement statement, whether it's on an affidavit, a deed, or other closing documents. The settlement agent needs that information anyway. So most of the information has already been provided to the settlement agent in advance of closing. Certainly, the settlement agent has that information, just part of their normal job. They have to get that information. But some things, they don't get to the last minute. And so the biggest thing I could say is everybody needs to be educated about this. And everybody also needs to understand there's going to be a cost associated with the settlement agent preparing or having a third party prepare this form. Um, the government is estimating 2 to 4 hours to fill out the form in detail and upload it and submit it to the government. Now, whether it actually takes that long or not, I don't know. I haven't sat down and tried to type one out. Um, but, you can imagine just that number of fields, even though they're fairly basic information, it takes time to go through, populate those fields, make sure the information is accurate, and then ultimately upload that form to the federal government. The reporting agent, the settlement agent, in this case might be somebody, an office like mine. We're liable for negligent uh, reporting. So if we screw the form up, we can be fined for that. If we have a pattern of screwing the forms up, we can be fined for that. If we file the form late, we can be penalized for that. And certainly if it's more nefarious than that, and we just intentionally don't file the form at all or ignore obvious discrepancies in the information we're provided, we can be criminally penalized as well. So it's a serious uh, report, but it's not overly complex. And I think if everybody understands that it has to be done, and it manages their expectations as to what your settlement agents are going to charge you for that service. And that'll be something that the market typically is going to flush itself out. I've heard, anything from, $300 to $400 all the way up to $500 or $600 for fill this report out. Um, but again, it takes cooperation from everybody involved in the process. If there's a mortgage broker involved, the mortgage broker is likely going to have a bunch of this information in advance, and I suspect there'll probably be opportunities where brokers might add filling this form out as an additional service or a product that they can offer in connection with their mortgage brokerage package. Really, obviously, that's going to be up to each settlement agent to determine who they want to allow to fill the form out. Because ultimately, again, if it's my responsibility as the closing agent, which is the tip of the spear for reporting reporters, as they call it. Um, if I'm going to offsource my obligation to fill this report out, I need to be fairly confident that whoever's doing it's going to do it the right way, and will be there for me if there's problems with the report they submitted on my behalf. Um, so, again, I don't think this is a panic moment here. This is just one level of complexity that um, adds to things that people like me have to do. We Settlement agents in the state of Florida have been dealing with similar reporting requirements through what they call the geographic trafficking orders or targeting orders, I should say, targeting orders. And I think there's 11 zones that were in the state of Florida, mainly in South Florida. Settlement agents in Jacksonville didn't have to deal with that much. I know I've never filled one out. But if there's a targeting order for a neighborhood in Fort Lauderdale, that certainly the closing agents that were in Fort Lauderdale were familiar with this process, and they had to provide a lot of the same information, although it was a much more abbreviated form. It's my understanding that those settlement firms they knew they had to do it, and they provided the information. Last year, or maybe the year before, I can't remember when it went into effect and then went out of effect. We had a similar report requirement for people, again, like myself, who might form an entity for somebody, form a new LLC. There was beneficial ownership report requirements that we had to file with FinCEN as well. And fortunately, or unfortunately, that reporting scheme or mechanism was abandoned. I believe the Trump administration might have had something to do with that, made that go away. But now this came up, and so the lobbyist and didn't do a very good job of making this reporting requirement go away. Certainly, the federal government has a legitimate interest in trying to police and prevent money laundering. And this is another kind of tool in their toolbox to fight money laundering. I I hesitate to call this a problem, but certainly it's going to add some cost to a typical transaction, and that's unfortunate. Um, Anybody have any specific questions? I'm happy to do a deep dive. There's lots of information available on this program uh, on the FinCEN website. A lot of the title underwriters have kind of canned uh, presentation material, PDFs you can look at. There are going to be some new forms that will be generated. Every settlement agent will probably have a slightly different version of a certification that people will fill out and sign at the closing, where they confirm that the information they provided the settlement agent is accurate, such as here's all the 25% or more owners of my LLC. They provide that information to the settlement agent. That's some of the material or information that gets uploaded to the form, and somebody's going to certify that information was accurate at the closing table. Again, not too much different than your typical LLC affidavit. When you're borrowing money and you're using an LLC to do it, typically the closing agent is going to ask for an affidavit that somebody signs confirming that all of the organizational documents that have been provided are true and correct. And so that's not changing. But it's just one of those things that there's going to be a little more of a hyper focus on it from the settlement agent's side of the table, because we want to make sure that since we're responsible for filing this report, when everybody leaves our closing table, we've got all the information we need to get that filed.
Okay. I don't know what she's tapping. So my question, Duane, is what about these LLCs? I know this is probably not like we're Florida, so it is what it is. But the LLCs that get buried under like the states that don't report, like the Wyoming and Utah LLCs that will not tell anybody who the owner of that LLC is. So like there's people that do that so that I guess they can't be found or whatever. Is that going to change?
Those people will have to provide all the information on the underlying beneficial owners. So if they have multiple layers of LLCs that try to hide the true beneficial owner for liability purposes, that will not be something that shields them from providing that information to the federal government. Now, this information is confidential, um, so it's not like the general public can see who the owners of your Wyoming LLC are. But I need to know that as the closing agent, and the federal government wants to see it as part of their anti-money laundering process. So that answers your question. Yes, you will have to provide that information, but no, it will not be part of a. It's not like you could look on Sunbiz, and because of this new rule, I suddenly have to publish this on a public website.
Guys, we also have Sean Bailey at this meeting right now. He works with a lot of you folks for loans, and if he hasn't, you should probably try him out. He works with a lot of hard money lenders and private lenders as well as institutional. And so if you have any questions for him or for Duane, please type them in the chat box related to this new reporting requirement. So we're going to open this up so that anybody that has questions can type them in.
Gavin, I don't know if you can hear me or not, but this law affects every transaction, not 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 just probate transactions. In fact, probate transactions that are where the property is passed to one of the heirs is specifically not included. But if you're buying property from an estate, then that transaction and you're using non-institutional money to acquire that property, then that transaction would be reported. This is all about buyers. It's not really as
Wayne,
much
we can't
about
hear you. I
sellers.
don't know if other people can hear you.
What?
I could hear you.
Okay. I don't know if I answered your question, Gavin, but yeah, you definitely have to report a transaction. Really, any transaction that involves an entity as is defined in the rules, which again would be basically any entity that you might create for your investment purposes, is going to be required to fill out or have somebody fill out this form.
So really, it's just like a disclosure. That's all it's doing is changing the disclosure around the transaction.
That's it. So what we're doing is we're disclosing the name of the buying entity, the beneficial owners of that buying entity, and the source of their funds. I mean, in simplistic terms, that's what we're disclosing. Unfortunately, it takes 114 or whatever fields to provide all that information because we're also providing information on the transaction, the property, the purchase price, in addition to the source of funds and the beneficial ownership of the purchasing entity.
So if I'm in the middle of a transaction and I'm assigning it to another buyer, they also have to disclose and be included in everything.
The assignment of contract is not specifically included. But your end buyer, and that'll be part of the challenge that we have, as you know, Gavin. A lot of times assignments, you don't know that you're going to assign it or who you're going to assign it to until maybe a couple of days before the closing has to occur, right? I mean, it's all kind of a scramble. And when you assign it to this new entity, that closing agent needs to know all that information about that entity so that they can make sure they have their form filled out. Again, it shouldn't be that difficult. But I can't imagine, I know, just kind of thinking it through from my perspective at my office, I'm not letting the closing conclude until I know I have all the information I need to fill that form out. Even though I'm not going to fill the form out for a couple days, or maybe I've got 30 days to fill it, fine. But I need to make sure I don't have to call anybody back to get this critical piece of information after the closing because I'm on the hook for it once I let that deed get recorded and take that money and disperse it. So you bring in a new buyer at the last second, you're going to sign it. That guy needs to be prepared to provide this information to the closing agent so they can make sure they check all their boxes. It shouldn't be that difficult. Operating agreement, a statement of beneficial ownership. But again, I recognize that some people have gone down this kind of rabbit hole of liability protection rabbit hole, and they've got 5 different LLCs to shield the true owner. And I'm not going to comment on whether or not that works or not. That's not really what I'm asked to comment on. But if you're going to do that, in this particular case, at least from what I can tell right now, you're going to have to say who that true beneficial ownership owner is. And if you think about it, if that same entity, that same Wyoming entity, is going to borrow money from any hard money lender, um, certainly ones that are, quasi-institutional, such as like a Lima One or a Kiavi, they're going to want to know kind of the ownership structure a bit. They may not care about it as much as a regular lender would, but they're going to want to know, hey, who are my members of my LLC? Who has the authority to sign for this LLC? And so these questions are questions that should be asked in most residential transactions, especially when there's a loan involved. I know in my case, as a title agent, my main job is I want to make sure, obviously, I've got a valid deed, so I had the right party signing the deed. But if I'm going to be a secured transaction, I need to make sure the parties that are signing the mortgage are the appropriate parties to do that. Well, how do I determine that? I need to see an operating agreement. If you see me an operating agreement that shows 3 different layers of complexity, guess what I'm asking for? I need to see all these other operating agreements so I can make sure I tie it all back to the person that's signing that document. And hey, we get pushback. Well, why do you need to ask for that? My other closing agent didn't ask for that. Well, everybody does their own thing. But at the end of the day, if it's not clear to me from looking at that first document who the signing party is or the authorized person is to sign for that entity, I'm going to ask more questions. Because at the end of the day, I'm ensuring your lender that they have a valid mortgage. And I can't really ensure that they have a valid mortgage unless I feel very confident that the person that signed it was authorized to do so.
Got it. Thank you.
Yes, sir.
Can you guys hear me now? You're popped in the old headphones. Um,
Yeah.
I can hear you.
I don't think you turned your school down. Sorry, Bernadette, I'm in the same office here. Duane, stop me at any point here, but I did want to touch on kind of what you said earlier on the hard money lending side. As long as it's an institutionalized lender that has to be MLA compliant, or the Money Laundering Act and things of that nature. As a licensed loan officer, those are things that I have to continue to get my education on my licensing and apply for and pay for every year through those. But I think one thing that we spoke about is I'm a hard money broker. So I deal pretty much strictly 90% of the time with institutionalized hard money lenders that do large volume, that are very competitive, that are not your local, hey, I'm going to borrow it against my IRA, or capital investors that are actually giving their own money as a hard money lender for these types of transactions, where that would cause and trigger uh, the FinCEN activity to occur, if I'm not mistaken, because we have to verify that individual who's letting you borrow that money. Now, a lot of the lenders that I use should already be compliant with the MLA stuff and should, these are recorded mortgages and they're doing such high volume. It would, and I am working on verifying with all of my institutionalized investors and lenders on these loans that, I do probably 10 to 20 loans, hard money loans a month. I would be very shocked. Duane made a point. We'd be shocked if they are not reporting and being compliant to the MLA guidelines when they're recording these mortgages. So, after hearing that from Duane, I don't think it's going to be that big of a drastic deal on my side for helping my investors with that loophole. And we're going to, obviously, this is a learning curve. We're going to find out real quick whether or not they're compliant or they're, regulated in that regard. But if so, I think the only ones on the hard money that we need to be aware of is obviously the cash capital investors that are using their directed IRA accounts where they're letting you borrow money, that are going to be private investors, that are going to be more of your private money lending sector as opposed to your hard money lending from institutionalized people that you can, Google. So hopefully that'll take a lot of stress off people. Gavin, I know you use Kiavi a lot. You have in the past. I want to say Kiavi is going to be an issue where we don't have to come across this problem, this platform, because they should be compliant. They're the number one hard money, lender, in the nation. So if they're not compliant with the MLA guidelines and they're not reporting and doing what they need to do, we'll have those discussions. I will say, ironically, I did reach out to my, my upline there, and I said, hey, what's the situation with FinCEN? And they're like, what's FinCEN? So it's not even on their radar, which is kind of funny. So they're not, like I said, I don't think they're too worried about it affecting them and their business whatsoever, which kind of tells me that it shouldn't affect anybody's business on the hard money lending purchases from, those types of lenders.
I'll read the definition of a
Hold on, Bert.
finance transfer.
You can't hear him because you turned it down, but Duane's talking. Sorry, Duane. Bernadette was talking.
That's okay. And so basically it says that the transfer is secured by a transferred property extended by a financial institution subject to anti-money laundering program and suspicious activity report obligations. So if it is one of those, in other words, the money came from one of those institutions, that's extended by a financial institution subject to AML program requirements and suspicious activity reporting requirements, I don't have to worry about it. I don't have to, that's actually a finance transaction. I'm okay. And more importantly, for this conversation, is I, as the reporting person, am authorized to rely on information from the lender confirming that they do have an obligation to participate in AML program and report suspicious transactions. I can rely on that unless I have reason to know they're lying. Um, but so in the case that you just mentioned, I would, and again, I think every settlement agent has to make their own determination, but I'm probably going to be comfortable. I got a mortgage broker involved, and Sean, you're going to sign something who is also a licensee, and you're going to say, "Hey, I confirm that myself and this lender are obligated to participate in these programs." I'm going to move on, and I'm not going to worry about this report. If you're not willing to do that, or you don't know, or I don't have a good feeling about it, and some of the comments that I've been reading, obviously, if somebody says I'm required to do it, but I'm an individual. Well, I know an individual is not going to be required to do it because it doesn't apply to individuals. So whoever's loaning their own money out of their retirement account or their own personal funds, they're definitely not going to be the type of lender that we can consider to be a true finance transaction. So I'm going to disregard their statement because I know it's not true. Even if they go through and they check a few boxes and they act with some diligence to make sure they're not dealing with a money launderer or terrorist, they're still not subject to the requirement. Um, to they're not subject to those rules because they're individuals, and those rules don't apply to individuals. So um, that's why the government's saying, "Hey, look, if you're required to go through the check the boxes." And we have the ability to come in there periodically and talk to you about whether or not you've been checking the appropriate boxes. We're okay with that. But it's the private individuals and there's obviously millions and millions of transactions that are taking place all the time. The government can't possibly pay attention to all that. So they're relying on these sorts of reports so they can focus. And all of a sudden they can say, well, this guy's loaning a bunch of money out of Jacksonville. It's a private individual. Maybe we need to check and watch some of his transactions because we don't know who he's loaning money to. And more importantly, he may not know who he's loaning money to. And that's the key is they want to make sure.
So my question then is, so your private people, like you're talking about, that are loaning out of their 401k, um, you're not going to expect them to be AML compliant. Those individuals for those loans will have to go through the required, whatever the required questionnaire, documentation, and you're going to file that report, or you or whoever you outsource it to would be filing the reports for those entities. Now, with your hard money lenders and your Kiavis and your people like that, are you going to just be requiring them to sign a legal document that they are AML compliant, and then do they file the report, or are you still responsible for filing on their behalf?
Yeah, we're not gonna if they're exempt, then there's not gonna be a report filed, and we're gonna have each closing agent's gonna have their own um process to make sure they're comfortable with that, so whether it's an affidavit that's signed by a mortgage broker, whether it's their own closing agent picks up the phone and calls the lender and asks a question and writes it down. I talked to so and so at Kiavi on this day, and they said they were compliant. Then everybody's going to have their own kind of deal. I Somebody asked a question about a link about this form. If you go to www.fincen, FINCEN.gov /RRE, that's got the rule I believe it's got the report, it's got all sorts of information, filing resources, frequently asked questions. It's everything you need to know is at www.fincen.gov/RRE. And again, not a whole lot to see here on this form, but it is a you know somewhat voluminous. Um, but again, nothing that really um, jumps out at me as a problem. It's not a overly complex form. Where it gets complex is when you have multiple layers. I think like we started out the conversation, you have 3 or 4 different companies involved, and each one of those companies, let's say we got two entities that are partners. Each one of those partner entities have multiple layers of beneficial owners. That's going to take, and there's the report filer has the ability to add as many of those layers as are necessary to give the complete picture to the government. And there's all the, just add entity, add entity. And again, that's why the form can take a few minutes because there's a fair amount of fields to fill out.
And just for clarification, guys, before anybody goes jumping on the web and thinks they're going to be proactive and just fill this form out and send it or store it or whatever, my understanding is that's not how this works. This has to be done by an authorized entity, such as a licensed mortgage person or your settlement agent, your title company. Is that right, Duane?
You broke up on me on that one.
I don't know.
What was your question?
My question was, before everybody runs on the web and tries to find this form and like pre-fill it out and be all proactive, it's not something you can just fill out yourself and
No.
store on your computer. It has
No.
to be done by an authorized individual. Is that right?
It has to be done. The settlement provider, there's a list of people that are supposed to do this. And the settlement provider is the one who's responsible, basically. I mean, there's others that could be responsible, but coming in and handing a filled out form really doesn't do you any good. Now, making sure you provide the information that that is necessary for somebody to fill out the form is important. And maybe if you wanted to, um, if you wanted to be proactive and you were able to fill out the PDF and print it out and submit it over to your title agent with as much information as you can, so they can then turn it around and submit it. Um, I guess that might be helpful. And I think probably, I don't know whether or not somebody's going to say, "Hey, yeah, fill that out and don't worry about any fee for this." I don't know. I can't imagine that. Again, at this point, from what I know about this process, is there's going to be a little time consuming and there are going to be charges associated with filling it out. But I do think that, going online and finding the form and understanding all the fields that I will need is a step that everybody should take. And now I'm looking at that. I'm trying to actually uh, fill out one of the forms, and I've got them in different methods, and then are telling me I have to have a new Adobe. Anyway, for that particular form. But anyway, if you go online there, play around that FinCEN website. It's got lots of information about this process, and I think it's worth looking at if you're concerned or want to have some more knowledge. That's a definite recommendation. Sean Bowen, were you able to hear what I said about the FinCEN website?
So it looks like it is on the BOIR website. If you Google new FinCEN reporting form, it will a link will come up on Google to the beneficial ownership information report. And it kind of breaks down the e-filing system, some important information. and some things like that. Now it does say there, I don't know that these deadlines are completely up to date or not, but there are some frequently asked questions on there, and some other things like that that people might find useful if they want to look into it further.
Again, that FinCEN website I gave you, it's got everything you need there. It's actually got the form in PDF. It did with the fillable form you have to have the newest
Maybe
this thing for you.
questions for either Duane or for Sean that they would like answered before we close the meeting.
If you go into reference materials, the form read only form is one of the forms, and it's actually 111 potential fields. Obviously, all those fields won't have to be
All
filled
right,
out.
guys, this has been recorded. Oh, sorry.
I'm sorry.
I've got another question. I think Bernadette kind of touched on it a little bit, but my question was kind of around you guys mentioned there's like some immunity basically around like the larger institutional investors who may not have to do some of this stuff. But like if I go borrow 100 grand from a friend, he sold some stocks to lend me some money and I pay him a return. How does that come into play? You're on mute.
He'll have to provide his information. I'll need his name. I'll need information about his bank account, his routing number, all the stuff. And at the end of the day, I'm going to get that anyway. As soon as he sends me a wire, I'm going to have his
Well,
routing information. So it's not like
well, Duane, what about? Sorry to cut you off. It, what if during that transaction, like Gavin does this, where he gets a private money lender or an investor or capital investor that wants to JV on a deal, that they're not actually purchasing the property, but let's say they just give Gavin $100,000 right into his bank account. Now that's what happens all the time on my side, on the institutional lending side. Like, hey, I need to see reserves or I need to see a bank account with 100,000 in it. They go to mom, dad, brother, sister. They go to um, Joe Schmo that's says, hey, can I borrow $100,000 to do this project? They give Gavin that money right into his bank account. At that point, do you still need that individual's information? Because at the time of transaction at the closing table, when he's wiring funds, it's coming from Gavin's account. Do we need to chase down the private investor that's letting him borrow those funds as a JV partner?
No, my understanding is that the money came from the transferee's checking account. We're not, as it says, the settlement agent and the report provider, we're not obligated to go source those funds. Now, that's what a bank would do, right?
That's what I'm supposed to do.
Certainly your own bank or financial institution may have questions about that. That's their job, right? But my job is to make sure I know that money came from Gavin's checking account at Synovus Bank. Here's the account number. I'm not going to go get in the weeds on where he got it from. But if it came from a third party directly to my trust account, whether it's secured or not secured, I've got to tell the government where that money came from. And so
Did that answer your question?
That was more of what my question. Like, if let's say I'm borrowing funds for the purchase price and I'm doing the rehab, and so they directly fund the account to like Duane's office, as like the mortgagee. Like, how does that
yeah, I'm
affect
reporting
everything?
that. Yeah, so the mortgagee. Let's just say you borrowed it from your brother, and you're going to give your brother a little loan, a little mortgage on the property, and you're going to fund the rest of the rehab out of your own cash after closing. That's considered a non-finance transaction, even though he's financing it because he's not subject to these AML rules or suspicious activity report obligations. It's considered non-finance. So I have to have his information. But again, I'm not really asking for much other than his name, his account number, his routing number, which I'm going to get anyway. And if you think about the dilemma of a closing agent in general, oftentimes I receive a wire. Let's just say I get a wire for $5,000 for somebody's deposit, and ABC LLC is the buyer, but the wire came from John Doe, right? And now there's a binder dispute. Well, I ABC LLC is the party to the transaction. I have no idea who John Doe is, and it puts me in a spot where I'm trying to, well, who has the authority to release this deposit? Who has the authority to even tell me to apply that deposit for the ABC file? So we're already kind of asking for that information. And when I see something come in right now from a wire comes in from a party who's not named on the transaction, I'm asking these questions anyway. Who is this guy? Where do they get this money from? The last thing I want to do is take somebody's money who's not part of my transaction, apply it to the transaction, and then have them come out, oh, gotcha. You weren't authorized to do that. So and that happens more than you might think. Because again, you might say, listen, hey,
So it's a simplified amount of information from the private individual, the brother that you just gave an example of, and it's like his bank account, his routing information, whatever. Where does the 2-hour long form and filing whatever thing come in? Which individuals does that apply to?
um, if the transaction is a qualified transaction or a covered transaction, we have to report it, period. If it's cash, if it's hard money, that's it. If it's residential real estate and there's an entity involved, that's it. We have to fill it out. There's a hard stop. No ifs, ands, or buts. The only way we get around that is if you're borrowing money from an institutional lender that is subject to AML and SARS reporting obligation. That's it. And so,
So real quick, because I'm hearing, everybody's chirping in my ear. I'm the lender, and every title company that I deal with or talk to or involve a purchase contract, they're all yapping about FinCEN, and some of them are nightmarish. That I've heard, hey, I need to get bank accounts, and that the borrower who's buying under an LLC through hard money or whatever the transaction is, it's much more than just the 114 or 111 questionnaire that they have to fill out. It's documents that they also have to provide, such as like social, driver's license, all LLC operating agreements, like just a stack of paperwork. Now, this is just what I've heard. I don't know. I'm not,
well,
I'm not the one.
I'll just say this. I have to get that paperwork anyway. I mean,
Right. So is that where people are all of a sudden, because Duane, you do things by the book, and I appreciate that. I'm glad you do that. A lot of other title companies don't require, or they don't. At least they don't ask. From
well,
my understanding, there's
I
some that don't
wouldn't,
get those documents.
I wouldn't necessarily have to ask for an operating agreement in the past if it was a true cash deal. They're sending me money and no mortgage involved. I don't necessarily, all I really want to make sure, I want to make sure the entity is active. And I never want to put a deed into a non-existent entity. That's a problem, right? So I want to make sure the entity is active, and I can probably look that up on Sunbiz. I don't necessarily have to have information on beneficial ownership. I would like to know who's going to be signing for the company, even if it's just the settlement statement. I'd like to know who the manager is. I'm typically asking. Now, certainly, I've got to ask when there's a lender involved, hard money or otherwise, right? I'm not going to let you sign a mortgage unless you give me your operating agreement. So I know who the people are that are authorized to do it. So I guess to your point, Sean, would be yes, maybe there's a few more documents I'm going to ask in a true cash transaction to determine who the beneficial owners of the buying LLC are. That doesn't really cause me a whole lot of heartburn because, again, I pretty much asked for it anyway.
So I just didn't know if there was a document list, because like I said, there's a lure going around of, oh, we're going to need the blood of your firstborn child in order to get this, to the closing table. So the myth here that it's freaking everybody out, which I think, after this conversation, it's kind of like, hey, what's, after you've just enlightened all of us, or at least enlightened me more, it's like, what are we really stressing out about? If it's 114 questionnaire and all the documentation is normal that you get from a hard money lender anyway, such as driver's license, sometimes I don't need bank statements, but LLC documentation, if that's all that's needed in this package, plus the 114 questionnaire, like I can have an assistant fill out all that stuff that's, relative or pertinent to the transaction itself. And then this won't even be an issue for anybody in that regard, unless it's from what I was told, it's like specific information that I can't gather from the borrower because it's requiring, a lot more personal information than I would request.
I can't imagine I'm looking at the page right now that talks about transferee information. That's what this is all about, right? I mean, obviously the lender's information is also important, but it asks for the type of entity, its name, its address, the type of identification provided, um, who the beneficial owners are, who the signer is. I mean, just basic stuff. Now, the beneficial ownership evaluation requires somebody to look at the organizational documents. Okay. And one of the things that I run across is that oftentimes these, especially new investors or investors that don't do a lot of deals, they don't have organizational documents. They don't even have an operating agreement. And so they're going to have to get one, right? They're going to have to, at the very least, they're going to have to certify who the beneficial owners are. Now, if a title company, um, it feels like this is overwhelming, then again, the answer is there's third parties that I can literally send, and I'm probably going to use one until I got to get my head around how easy it is for my staff to fill the form out or how much time it takes them. I'm going to use a third party. What those third parties do is I send them some very basic information. Here's the buyer's name. Here's the seller's name. Here's a contact. Here's a phone number, an email. And they're going to take and run with it. This third party company is going to ask these individuals for all the information they need to fill out this form on my behalf. Now, if the individuals, the buying entity, the transferee doesn't provide the information, then the deal's not closing. At least not at my office. And I can't imagine any of the other title agents that I've spoken with about this are going to allow a transaction to be completed through their office unless they have all this information. But again, I'm not seeing anything here that, I mean, if you're in business and you don't have an operating agreement and you don't have the ability to identify who the beneficial owners of your company are, I'm sorry, but maybe it's time for you to figure that out.
Yeah, I mean, any transaction that I have to deal with, I require bring if you're sole proprietor, sole ownership on the LLC, still need to see that you're, what that operating agreement is. So it sounds like nothing's really going to change in operations. It's just the reporting and then and then information compiling onto one spreadsheet that you get filed in. So,
Well, to give you an
really,
example, Sean, on the report
It
itself.
sounds like it's not so much the gathering of the documentation as it is this new requirement that this report be filed per transaction within 30 days. That's probably maybe part of the time consuming part for whoever's going to be responsible for doing that part of it. Just
Well,
because
again,
whoever takes that burden on is liable for any fees or fines or anything if it doesn't get done in a timely fashion like it's supposed to.
Well, again, in my opinion, especially if it's a deal going through Sean, Sean is going to be gathering most of this information, if not all of it, and before he even submits it to whatever lender he's brokering it through. I don't care if it's, a true private guy or it's, Gavi, right? He's got to provide them with a basic package to underwrite and submit this loan. And so he's going to be asking for this stuff anyway. So I don't see any spot on this report where I'm actually uploading this data. I'm I'm making statements based on information that I've gathered. And certainly I don't want to go out on a limb and sign my name on a report that says that, Bernadette's the 50% owner of this company unless I'm able to verify that and have something in my file that states that. Certainly an affidavit from Bernadette, if it's her company buying it, that confirms that. That way, if they come calling and say, hey, well, that was wrong. Well, okay, here's the document she provided me. Here's the statement she signed saying it was true. How could I be responsible for that? And all of the the information that I've seen about this program, it gives the filer a safe harbor, if you will. I can reasonably rely on information provided to me by the parties to the transaction. Um, and as long as I don't know that it's false. So give me your information, certify it's true, and file the report. Clearly, it's just another kind of annoying little thing we're all going to have to do. And eventually, I'm assuming there'll be some tweaks to it. For instance, in the BOIR beneficial ownership report scheme they had last year, you could get what they call a FINCEN identifier. And that would identify a company that was already uploaded into the system. So, you know, XYZ company files this information. They know who the beneficial owners of that company are. And hopefully in the future, when we fill out this new report, I'll be able to go in there and type in the FinCEN identifier of the transferee, and then boom, all that information is already there. Now, right now, that's not a possibility. And there's some comments in the FinCEN world where they recognize that that's not there. But I think probably eventually, certainly once the trade associations push back, why can't we do this once? Because if I'm doing the same deal with the same buyer 50 times this year, I don't want to have to type his information in 50 times. I want to type his unique identifier in. It's uploaded. But again, right now we can't do that. So this is a work in progress, I think, and that's an easy one for them to fix, in my opinion. And that way, once you set them up once, every one of these private guys that's doing these deals gets his own identifier, and maybe even this lender does too. Um, but that doesn't change the requirement I provide information on where the money's coming from. It just confirms the beneficial ownership of these entities. So I, that's basically it.
Well, guys, we have now taken up an hour of Duane's time. I'm so thankful that he was generous enough to do this for us. You know, attorney rate per hour can get expensive, and glad we're not paying for that today. So thank you so much to Duane and also to Sean. I know that Sean is going to work really hard to kind of partner with Duane on, you know, streamlining and simplifying this in any way that he can from his end, because he writes loans, as you guys know, for private lenders, hard money lenders, and institutional lenders. I'm also more than happy to help if I'm representing you in something and I can do some of this for you guys legally and that I'm allowed to. I'm always happy to help Lisa and Brian, you know, take anything off their plate that I need to. So we did record this meeting. I am going to be able to send a recording out. So if any people did not make it, I know there was a lot of people that said they were going to try to log in, and it looks like most of them didn't. So it was recorded, it will be packaged up. I can send it out to you. If there's anything else, follow-up questions, feel free to email them to me or text them to me or to Duane or to Sean. And we're happy to, you know, help you get all of this resolved in any way that we can.
Okay. Thanks for setting this up, Bernadette. And nice talking to everybody. And you know, like I said, like she said, feel free to give me a call. But if you wanted to talk about this, or even if you have borrowers or people that need assistance getting a basic operating agreement together, that sort of thing, I'm happy to help with that as well.
Okay. Thank you, everybody.
Thank you. Bye.